Afternoon, everybody. My name is Jack Keyes. I was formerly the probate judge in New Haven, and I'm here today with Frank Forgione, who, like myself, spent 32 years as the North Brantford probate judge, and Chuck Tiernan, who has just recently been elected probate judge. And would like to just go over some of the commonly asked situations and questions that people have in probate court. It's a complicated process, but these two gentlemen are the best at it. So let me just give you an introduction. Probate court has 5 major areas. That is decedents' estates, conservatorships, handling trusts, inter vivos or otherwise, guardianships of the minors, both person and estate, and guardianships of the intellectually disabled, which are difficult. So with those 5 areas of just a rough outline, I go try to rotate between the 2 esteemed members of the panel here. I start with Frank because Frank's a lot older than any of us here. And Frank, just do a quick rundown on estates.
Sure. Now, there's several types of estates. There's full estates where you have a will. There's estates where you don't have a will, which is called intestacy. Testacy is called an estate with a will. There's an estate which is called a small estate procedure when the value of the estate assets is not greater than $40,000 and does not include real estate only in the decedent's name. So the process is different for each, but it's also efficient. People have a concern that, why do I have to go to probate? And essentially the probate court acts as an overseer to make sure that the fiduciary and others do what they're supposed to do. So the process, although seems intimidating, it's actually relatively straightforward. The staff is tremendous and help most people through the process if they're not represented by lawyers.
So Frank, just go through this. When you have a will, what you have to do, and when you don't have the will, who you have to notify. Just do an outline of that.
So when you have a will, you submit an application to have the will admitted to probate. When the will is admitted to probate, there's a hearing, and if there's no objection and no contest, the will is usually, if not always, admitted to probate. One thing you need to know is you need to have the original will. Sometimes copies can be admitted, but it's presumed that the copy, if that's all that exists, the original has been revoked. So once you have the hearing and the will is admitted, someone is appointed executor, and that's the person who's in charge of handling the estate, gathering the assets, the accounts, the real estate, opening up an estate account in the name of the fiduciary as executor of the estate, making sure that all of the assets are gathered, any estate expenses or claims are paid. Paperwork is filed with the probate court that shows just what those assets are. And then at the end of the estate process, a final accounting is filed which shows what the assets were, what the expenses are, and that distribution is being made in accordance with the will.
So let just give you a question and help me out. Is I'm acting stupid and it's not really acting. So I convince, after my wife dies, another woman to marry me, but I don't have a will. Who gets my property?
And you've married the second wife.
Yes.
And then you die.
Yes.
And you do or do not have a will.
Don't have a will.
So if you do not have a will, under the laws of intestacy, your wife, and you have children from the first marriage.
I do.
So your new wife and the children of the first marriage would split everything 50-50.
Okay, that gets me home.
Yes.
So Judge Tiernan,
yes.
Let's jump to conservatorships.
Yep.
So, and I'll give you a hypothetical on the conservatorships, using myself as the example. We moved to Brantford, and all of a sudden, I'm thinking the world is crazy. I go off the deep end. I become a Republican. I'm acting bizarrely throughout. What does my daughter, well, I already killed my wife, so what does my daughter have to do to get a conservatorship from you?
So usually what happens to begin that process is your daughters plural, would go have you evaluated by a doctor. and the doctor would determine whether or not you are unable to make both personal decisions for yourself and financial decisions. And to the extent that that report indicates that you have some cognitive impairment which makes you unable to do those things, they would then be able to do an application to have a conservator appointed for either or both the estate and the person. And what would happen is after that's filed with the court, we schedule a hearing, and we have usually, if family members are not equipped or wanting to be appointed conservators, we usually have a list of lawyers who act as conservators, and we have them come to the hearing. And normally what happens is we have that report admitted as part of the file, and then you have to question, I'd have to question you, and we have a series of statutory questions that need to be asked of you, and then also of the individual who is planning to be appointed as the conservator.
What safeguards do I have on my rights given to me by the probate statutes?
Well, first of all, you're entitled to be represented by counsel. And if you can't afford an attorney, the court appoints an attorney to represent you. And, you have the right to appear at the hearing and essentially, tell the court why it is that you don't think a conservatorship is necessary. And we get into these situations on a regular basis. And you're going to really have to rely on testimony from family members and the report to determine whether or not, in fact, you're not in a position to make decisions in a financial sense or in a personal sense.
Suppose I refuse to go to the doctor, then does that stop the whole process?
Well, it does not. If you refuse to go to the doctor, we can still have testimony admitted as part of the hearing that addresses your cognitive shortfalls, let's say, and we can proceed without that if, in fact, you decide you don't want to be subject to being evaluated.
So that's interesting. Let's jump back to Judge Forgione. About 5 years ago, Frank, I went to a seminar you gave on the new Uniform Trust Act. And now it seems like the whole world needs trust, wants trusts. And the law has really, in law, 6 years is nothing in the legal business. What did you see in your last couple of years as probate judge with the trust coming in?
Well, the new Connecticut Trust Code made dramatic changes to the law of trusts. And so dramatic that modifications could be made to trusts that perhaps the person who is what we call the grantor, the person whose trust it is, didn't even intend. Depending on whether beneficiaries consent. So what we started to see was a lot of litigation over trusts.
So, normally a trust begins with a grantor and then a trustee and then beneficiaries. Those are the three outlines. And were you finding that there were more and more trust issues coming to the court?
The probate courts were given a broad spectrum of jurisdiction over trusts, which previously they probably didn't have. The Superior Court had most of the trust jurisdiction. So what we were seeing were a multitude of trust applications with trust issues whereby the trustee would request authority to take certain actions, perhaps modifications of the trust were sought, perhaps what we call a trust construction was sought if the trust was ambiguous. So people started coming to the probate court, I think, for a number of reasons. First of all, we're incredibly efficient. The staff is excellent. The wait for a hearing is relatively short. And as a result, you can get in front of the judge and have your case heard in a reasonable period of time. Whereas sometimes if you go to the Superior Court, it takes a considerable length of time.
Let me give you a hypothetical, Frank. Suppose I'm the beneficiary of a trust, and the grantor thought I was a knucklehead, so I couldn't get anything other than the interest generated on the trust. But now I need money desperately to pay the taxes on the house or something like that, and there's a lot of money in the trust. Can the probate court do that?
Well, I think there has to be a motion filed to modify the trust, to see if other beneficiaries and the trustee consent to that. A hearing would need to be held, and the trust and the court would have to decide whether or not to take that action.
But it's possible now, right? Because
It's possible, yes.
Okay.
In theory, yes.
and what do you have any preferences on the trust? Do you think that there's too many, too little, or what are you getting when you in your litigation and when you were seeing them?
I think that a lot of people have trust to what we call avoid probate, but documents still need to be filed with the probate court, even though the probate court might not be overseeing the distribution of the trust assets. So I was seeing more what we call inter vivos trusts, where people were putting all of their assets into a trust, and when they died and were no longer the trustee and or the beneficiary of that trust, the new trustee would make sure that the trust was followed, and frequently those trusts called for outright distributions to the beneficiary. So yes.
So that's a great topic you raise. So basically, a revenue service form 706 is required on every estate. Is that correct?
CT 706NT for sure.
And so explain to me, when people say avoiding probate, and I guess the question is poorly phrased, no matter what, you're going to have to file a 706 NT or 706, correct?
Correct. State law requires that.
So is it true or untrue that you can get away with completely avoiding probate?
Can you get away with it? I suppose the issue is anybody going to find out?
Yeah, right.
It's certainly, I don't think a lawyer would advise you to avoid the filing. And essentially, you file and the probate court sends out a bill on behalf of the treasurer of the state of Connecticut.
Okay. Thank you. Judge Tiernan, have you done a lot with guardians of the intellectually disabled since you came in?
You know, I've been in the job for a year and a half, and yeah, we have had quite a few of those types of cases.
Just give us a description of that, please.
So, parents have children that have an IQ below 70. That would enable you, once your child reached the age of 18, to seek a guardianship for that child. And you know, it's an avenue for the parents to be able to be in charge of their kids in the same way or in a similar way to, you know, the rights that you would have as a conservator. You'd be making medical decisions for your kids. You'd be making personal financial decisions for your kids. But a petition would have to be filed. You'd have to present testing that would establish that the IQ is below 70. And it's important because it provides resources to the parents that they might not otherwise be eligible to access.
So there's state or federal money available, and
Yeah.
by that appointment you can then access the money?
Exactly, yes.
And are you getting a lot of those, or a few of those, or not as many?
Not a lot. You know, I think we've had probably a dozen in the year and a half that I've been the probate judge.
And have they worked out for the family as far as?
Very well, yeah, very well. And a lot of it was, you know, you had parents that they didn't know what to do with their kids at a certain age level, and they couldn't access the resources that they might otherwise with the guardianship, and it really has helped.
Well, that's wonderful. So I want to go back in time. I believe 20 years ago, Frank, with other of the regional judges, was the first chief judge of the New Haven Regional Children's Probate Court. Frank, describe what the need for that was and what we what we did, because I was in on that a little bit, but just describe what happened there.
Well, prior to the creation of the Children's Court, we, as probate judges, had I will say, a lack of information regarding situations involving children who are subjects of guardianship, custody matters. DCF would do an investigation, we would get a report and render a decision on guardianship, custody, termination of parental rights, and adoptions. But it wasn't enough, Jack. We needed more. And you spearheaded the movement to get the judges in our region, 10 separate probate courts, to unify and push for the creation of the New Haven Regional Children's Probate Court with Jim Lawler as our chief court administrator. And legislation was passed, and what happened as a result of that is we were able to hire social workers on staff who work together with DCF to provide a comprehensive analysis of the current family situation, the dynamics, the needs, the problems and issues within the family, and the recommendations for what is in the best interest of the child. So the information gathering was extraordinary, and the evidence presented to us was like nothing we'd ever seen.
So each one of those cases begins with a tragedy, a parental failure, a parental death.
Yes.
What advantages does go in a probate court have as opposed to go in a juvenile court or any other court when you want to go to probate?
Well, I would say this at the end of the first year we were opened, and this, I'll never forget this. Somebody came to the probate court on behalf of a couple of children whose parents had passed away, and came to the counter and said, "We're coming here to the Children's Court because we were told that you can help us." And that's what I like to think we do. Sometimes the decisions are very difficult. Sometimes there aren't great options. But with social workers on staff and DCF working with us, we're able to get that information that's so badly needed. And I think we've filled a void, and the decisions that are being rendered are much better than they were 25 years ago.
What's the time frame on those?
Well, from when a petition's filed, let's say for custody or guardianship, and this is not in a divorce context, it's heard within 30 days. And there may be a second step to it. It may go from custody to guardianship, which is in theory another 90 days. But the original hearing, the initial hearing, should be held within 30 days.
Are there grant programs available for the grandparents directly out of probate?
There is, unfortunately, the grants to these guardians who I would say are heroic because they are taking children under their wing into their household, usually family members, but sometimes not, to provide care and custody and sustenance for the children. And the money that they're offered and allowed to receive is not a lot, $1,000, maybe up to $2,000 over the course of an entire year. So we certainly wish that the state of Connecticut would provide more resources for the children.
Who funds those grants? I'm just curious.
The state does.
The state does.
Yeah, it comes through the direct grant to the probate administration.
Yes.
Have you been involved in custody cases?
Yeah, I sit every Wednesday afternoon in the Children's Court in New Haven, and I have to say you two who began that court just did a terrific job. And as Frank indicates, the resources, the family specialists, the DCF workers, you get such a really detailed amount of information about the case you're dealing with. It almost, I don't want to say makes it easy, but it makes it much easier than it might otherwise be. And you really get the whole picture.
Well, every one of those cases that we talked about today begins with a tragedy.
Yeah.
And that the idea is that somehow we not be part of the tragedy, or I guess "we" is a large word for two has-beens, but we didn't want to be part of it. With minors and money, just explain, if some minor has a car accident, gets $100,000 or something like that, what's the probate court do?
So let's say, for example, you have a child who's been involved in a car accident, and the attorney who's representing the child wants to settle that case, and the amount to be paid, let's say it's $20,000 or more, you'd petition the probate court to ask for a guardianship to be set up to allow the parents, in most cases, to be able to negotiate that settlement. So you give the authority to the lawyer to settle the case, and sometimes you'll get the lawyer in and talk about the case and find out, are you getting the best result for your client with respect to that case? You don't normally second guess the attorney who's representing the kid, but sometimes, you can have that conversation. And ultimately what happens is you give approval to settle the case, and then you indicate that the money that's going to be coming from the settlement is going to be placed in a restricted account, which the parents normally set up with a bank, and that money is to be distributed to the child when the child reaches age 18. Sometimes you get situations where now the child is going to be 18, and the parents want you to be able to make it so the kid doesn't spend the money on a car. They want the kid to use the money for college, but at the end of the day, it's the kid's decision.
Frank, in the 32 years that you were probate judge, what is the case you remember most fondly?
Fondly, that's
Big word for me,
That's
Catholic school and all.
quite a
but,
word. Fondly. Jack, there are so many, but I would say we used to handle a lot of adoptions at the Children's Court. And to have parents come in and adopt a child, and frequently perhaps their only child, the sheer joy and the impact that we had on their life, even though it didn't seem like we were having that impact, I can't tell you the feeling I would get from approving an adoption and allowing a family, which had been a family in fact, now to be a family in the eyes of the law, and to move forward as legally parents, children, and the joy in that courtroom. People would bring balloons, cakes, they take pictures. It was a tremendous celebration because it was truly a new beginning.
Well, I'm going to get with you there, Chuck, the next question. One day I was at the Children's Court, and it was, I was just late in the afternoon, and a grandmother and grandfather came in from somewhere in the South, and their son was stationed in Iraq at the time, and their the baby's mother had just taken the kids and taken off, and they had valid out-of-state court orders of custody. And we worked through the bureaucracy, which is awful because you got to register the order, you got to do this, and then we sent a wonderful resident of Brantford out to go see where the mother was, and she was in one of the worst drug sections of New Haven. And he went out and said, she's out there. And, the grandparents were thrilled. And then I said, all right, go out, get the kid. And by then the mother had taken off and she had headed. And we were all, just heartbroken that we thought we had missed the opportunity to really get the kid back where the kid belonged. And the cop, a wonderful guy, said, no, we're not chasing anybody with brains. She's going right home. She lives in Rhode Island. She's going to go right home to her father. So you got a Rhode Island trooper on there. An hour and a half later, she shows up. They grab the kids. It was the happiest ending of my career. And I didn't do anything but just sit there and file the paperwork. That was really the high point of what was a very mediocre career. Chuck, you only got a year and a half, so this is a tough question to you.
Well, I had an adoption, and Frank describes the feeling. To me, the adoptions are the most rewarding part of what we do. I have an adopted son, and it's just a terrific feeling to put these people together, and they just appreciate it so much. So I have to agree with Frank.
So
I had one last week at the Children's Court.
Do you buy him stuff? You get him food or anything like that, or you just sit there?
Well, we try, to have things available for the kid, and it's it's a festive occasion, as it should be.
Well, kick this over to one of the newer areas. Frank, you get the new area questions today. Explain the special immigrant juvenile status business in regional court?
Well, if a child is, and it doesn't have to be a child either, someone under the age of 18 is in Connecticut and we need custody orders or guardianship orders, they can file a petition that's called Special Immigration Juvenile Status, where we hold a hearing, and frequently the children, and when I say it doesn't have to be a child, could be 18, there's a different petition for that, but the children under the age of 18 are in the United States, usually living with a relative. And
Without papers, right?
without papers, and their parents or parent, whomever might be available in another country, has neglected them, frequently has abused them. The stories that these children tell, along with the guardian, on their journey to the United States is gut-wrenching. What they're exposed to, what has happened to them is, in many cases, unimaginable. And we will hold hearings establishing that they are entitled to special immigration juvenile status, and then appoint a custodian or a guardian. And the lawyers who represent the children, and they're very, very good lawyers, then are able to take those papers to the federal system and start the immigration process on behalf of those children.
Does it stay deportation if they're appointed?
Jack, I don't know that. I don't know that. I know that the decrees contain very specific factual findings to support the awards and the grants of custody that we render, so that these decrees can be used in the federal courts.
I believe it does. I didn't realize. I wasn't trying to be
No,
snarky, but I believe it does. And are you getting a lot of those?
We, in New Haven, yes, we were getting a lot of those,
And-
absolutely.
And some of the stories were the children would walk from wherever.
Gut-wrenching, those
Jack,
stories.
you know, some of the children were, exposed to not only physical abuse, sexual abuse, no food, nobody taking care of them. I mean, I say to myself, imagine you have a child raised in America, graduates from high school, and everybody disappears that has supported that child. Now, these are children who might be 10, 11, 12, 13, 14, 15, traveling hundreds of miles, accompanied by strangers.
Coyotes.
I just can't even emphasize the heartache and the hardship they've gone through.
Chuck, last one to you. Changes of name.
Getting a lot of changes of name. The probate system recently made it so you could get your name changed without paying a probate fee.
Free?
Free.
I don't hear a lot of that in government
And,
service.
It's interesting that, we get a lot of young kids, their parents are coming in and having, their names changed at a young age. And we have adult name changes. You file a petition, you indicate what your name is, what you want to change it to. You get a copy of the birth certificate. We check with the state police to determine whether or not you have any criminal record, and if you're trying, to have the name changed for some nefarious reason. We also check with the state to determine whether you're on the sex registry, sexual offender registry, I should say. And it's, a relatively simple process. You come in, they give you an explanation for why we want their name changed. Many times, you'll have a situation where the parents are divorced, and let's say maybe one of the two parents is out of the kid's life, hasn't been in the kid's life, and in those occasions, the parent will come in with the kid, and we provide notice to everybody, and sometimes that other parent doesn't show up to oppose it, and the child indicates a real desire to change it when we do it.
And what are there paperwork reasons you got to change the name to? Like birth certificates don't match, stuff like that.
Yeah, it's funny, people say, hey, this is what my birth certificate says and my passport says it, but it's not my, legal name. My license says something else, and I have to have it consistent with my birth certificate. Maybe I didn't explain that right. So we make that change, and then we give folks a list of places that they need to think about going to make sure they alert that agency to the fact that the name's changed.
So if I wanted to change my name to Rockefeller, would that do me any good?
I think it might.
Well,
You could do that. I mean, and there's absolutely nothing. Jack Rockefeller. It's
yeah,
got
I
a nice
do.
ring to it.
Yeah, I do too, but somehow I don't know that too. So when you do this, guys, right? And this is to you, Chuck, because you're the newbie here. Do you enjoy the job?
I love this job. I absolutely, from day one, I've enjoyed what I do there. You really can make a difference as a probate judge, and I was fortunate. You know, Frank Forgione is the gold standard, in my view, of probate judges. And Jack, you're in that same category. And, you know, if I could be half the judges you two were, I consider myself successful. But I really enjoy, we have a terrific staff in the Brantford Probate Court. I can't say enough positive things about them. They make my life and job as the probate judge so much easier. And I really believe we're doing a lot of good in the role, you know, I hope I am in the role as a probate judge. That's the whole point, trying to make people's lives better. And hopefully we're making that happen.
Well, if anybody's still awake out there, we're finished. Thank you very much.
Thank you.
Take care, Frank.
Thanks, Chuck.